Bill number 113 of 2020, the Farmers' Produce Trade and Commerce Promotion and Facilitation Bill 2020, a bill to provide for the creation of an ecosystem where the farmers and traders enjoy the freedom of choice relating to sale and purchase of farmers' produce, which facilitates remunerative prices through competitive alternative trading channels to promote efficient, transparent and barrier-free interstate and intrastate trade and commerce of farmers' produce outside the physical premises of markets or deemed markets notified under various state agricultural produce market legislations, to provide a facilitative framework for electronic trading and for matters connected therewith or incidental thereto. Chapter 3, Dispute Resolution 8. 1. In case of any dispute arising out of a transaction between the farmer and the trader under Section 4, the parties may seek a mutually acceptable solution through conciliation by filing an application to the subdivisional magistrate, who shall refer such dispute to a conciliation board to be appointed by him for facilitating the binding settlement of the dispute. 2. Every board of conciliation appointed by the subdivisional magistrate under subsection 1 shall consist of a chairperson and such members not less than 2 and not more than 4, as the subdivisional magistrate may deem fit. 3. The chairperson shall be an officer serving under the supervision and control of the subdivisional magistrate, and the other members shall be persons appointed in equal numbers to represent the parties to the dispute, and any person appointed to represent a party shall be appointed on the recommendation of that party, provided that, if any party fails to make such recommendation within 7 days, the subdivisional magistrate shall appoint such persons as he thinks fit to represent that party. 4. Where, in respect of any dispute, a settlement is arrived at during the course of conciliation proceedings, a memorandum of settlement shall be drawn accordingly and signed by the parties to such dispute, which shall be binding upon the parties. 5. If the parties to the transaction under subsection 1 are unable to resolve the dispute within 30 days in the manner set out under this section, they may approach the subdivisional magistrate concerned, who shall be the subdivisional authority for settlement of such dispute. 6. The subdivisional authority, on its own motion or on a petition or on the reference from any government agency, take cognizance of any contravention of the provisions of Section 4 or rules made thereunder, and take action under subsection 7. 7. The subdivisional authority shall decide the dispute or contravention under this section in a summary manner within 30 days from the date of its filing, and after giving the parties an opportunity of being heard. He may a. pass an order for the recovery of the amount under dispute, or b. impose a penalty as stipulated in subsection 1 of Section 11, or c. pass an order for restraining the trader in dispute from undertaking any trade and commerce of scheduled farmers' produce, directly or indirectly under this Act, for such period as it may deem fit. 8. Any party aggrieved by the order of the subdivisional authority may prefer an appeal before the appellate authority, collector or additional collector nominated by the collector, within 30 days of such order, who shall dispose of the appeal within 30 days from the date of filing of such appeal. 9. Every order of the subdivisional authority or appellate authority under this section shall have force of the decree of a civil court, and shall be enforceable as such, and decretal amounts shall be recovered as arrears of land revenue. 10. The manner and procedure for filing a petition or an application before the subdivisional authority and appeal before the appellate authority shall be such as may be prescribed. 9. 1. The Agriculture Marketing Advisor, Directorate of Marketing and Inspection, Government of India, or an officer of the state government to whom such powers are delegated by the central government in consultation with the respective state government, may, on its own motion or on a petition or on the reference from any government agency, take cognizance of Any breach of the procedures, norms, manner of registration and code of conduct, or any breach of the guidelines for fair trade practices by the electronic trading and transaction platform established under Section 5 or contravenes the provisions of Section 7 and by an order within 60 days from the date of receipt and for the reasons to be recorded, he may pass an order for the recovery of the amount payable to the farmers and traders, b. impose a penalty as stipulated in subsection 2 of Section 11, or c. suspend for such period as he deems fit, or cancel the right to operate as an electronic trading and transaction platform, provided that no order for recovery of amount, imposition of penalty, or suspension or cancellation of the right to operate shall be passed without giving the operator of such electronic trading and transaction platform an opportunity of being heard. 2. Every order made under subsection 1 shall have force of the decree of a civil court and shall be enforceable as such, and the decretal amount shall be recovered as arrears of land revenue. 10. 1. Any person aggrieved by an order under Section the 9th of May prefer an appeal within 60 days from the date of such order to an officer not below the rank of Joint Secretary to the Government of India to be nominated by the central government for this purpose, provided that an appeal may be admitted even after the expiry of the said period of 60 days, but not beyond a total period of 90 days if the appellant satisfies the appellate authority that he had sufficient cause for not preferring the appeal within the said period. 2. Every appeal made under this section shall be made in such form and manner, and shall be accompanied by a copy of the order appealed against and by such fees as may be prescribed. 3. The procedure for disposing of an appeal shall be such as may be prescribed. 4. An appeal filed under this section shall be heard and disposed of within a period of 90 days from the date of its filing, provided that before disposing of an appeal, the appellant shall be given an opportunity of being heard.